We're going to continue to finish up the section on the Alabama and state and federal court system. Last class we were finishing discussing the U.S. Courts of Appeal. We know that we are in the 11th Circuit Court of Appeal. That means that the Court of Appeal that sits in Atlanta, Georgia, has the required precedent and will control any of our federal courts in the states of Alabama, Georgia, and Florida. In addition to the 11th Circuit Court of Appeals, the 5th Circuit Court of Appeals is also important because prior to 1981, the states of Alabama, Georgia, and Florida were part of the 5th Circuit Court of Appeal. This means that anytime there is a decision prior to 1981 where the 5th Circuit ruled on a particular issue, assuming that the 11th Circuit has not ruled on that issue, the 5th Circuit decision is controlling and binding upon the federal courts even in Alabama, Georgia, and Florida today. A little bit of definitions. A typical case in litigation begins with the filing of what's called a complaint, and the complaint and any document that is filed in court for the judge to see are known as pleadings. After the initial complaint is filed, the defendant has a certain amount of time, and we discussed last class a 14-day response time, a 21-day response time, a 30-day response time, and a 60-day response time, depending upon the court in which the complaint was filed. And the defendant has that amount of time to file a responsive pleading, usually an answer. In addition to the complaint and the answer, other motions and documents can be filed in court that are all done prior to the actual trial of the matter, such as a motion to dismiss, a motion for summary judgment, a motion to compel, etc. The discovery process is an ongoing process in which each side discovers information about the other side's case. We discussed this in the Lebec versus McDonald's case, where McDonald's was able to find out about Ms. Lebec's medical history, as well as her medical treatment, the bills, expenses incurred, etc. In addition, Ms. Lebec was entitled to find out about the prior claims made against McDonald's for similar type of medical treatment injuries that occurred from the coffee being served at too hot of a temperature. Eventually, a pretrial conference takes place, at which point both sides meet with the judge and a discussion is had of certain matters related to the trial. The trial takes place, certain post-trial motions may occur, and then an appeal may or may not be lodged, depending upon whether or not grounds for an appeal exist. As we discussed last time, that doesn't necessarily mean that just because you didn't like the result, you can appeal. You must establish some sort of error that occurred at the trial court level in order to have a basis for a good appeal. Slide 23 has a typical complaint on there. I would tell you that's not necessarily a typical complaint, but it is a sample. It will have a caption where the court is identified, the name of the plaintiff and the name of the defendant. You won't see on the complaint a civil number listed because that number is assigned after it gets filed in. There is a factual allegation or a set of allegations that are typically included, along with sometimes statement of jurisdiction and usually several causes of action or theories of liability. And then at the end you have in the wherefore paragraph, it's called a prayer or prayer for relief, in which the plaintiff asks the court to grant certain relief that they're seeking, usually monetary damages in a typical type of a lawsuit. And there's a couple of examples of pretrial motions. You can read that and review. Some of the areas of discovery are listed there. Depositions are situations where sworn testimony is taken either of a party or of a witness. Basically, the witness or the party is sworn in, a court reporter is present, and one of the attorneys will ask questions of the deponent under oath, and the court reporter will take down every word that they say. Interrogatories, on the other hand, are written documents that are sent to the other side. They're written questions that are sent from one side to the other side, and the party receiving the interrogatories must answer those interrogatories. Typically, a lot of cynics say that interrogatories are answered by attorneys and depositions are the product of the actual witnesses themselves. And if you think about it, it makes sense, because the interrogatories are going to go from one attorney to the other attorney, and then they're going to have their client complete it with their help. And I'm not saying that any of the other PowerPoint slides that I'm skipping aren't important. I think they're fairly straightforward, though, and speak for themselves, so you can review those. Enforcing the judgment, I just want to mention one thing here. It is a very important part of deciding whether to pursue a matter in litigation, making a determination as to whether or not a judgment would be collectible. It is fine and good to have a case that's a great case, in which liability is clear and maybe even the dollars that are involved are substantial. However, if the defendant has no money or assets to satisfy the judgment, it's not going to do you any good to pursue it, and it'll be a waste of time and resources and probably money as well. And that's speaking from someone who has a judgment against a defendant for $1.5 million, in which I've never collected a dime of it. Okay, we're going to move on from sort of the judicial system and the litigation system to alternative dispute resolution, and it is a very big part of the world of dispute resolution these days. Basically, I like to say there are 4 different kinds of shuns. You have litigation, which is what we've been talking about this entire time. You have negotiation, which can occur inside or outside litigation, or at any time, or with any of the other dispute resolution techniques. And then you have mediation and arbitration. And I'm going to spend more time talking about mediation and arbitration than any of the others. In mediation, you have what is typically a voluntary process. Yes, a court can order a mediation. Usually they do not, and mediation typically takes place because both parties to a dispute want to have it resolved. Mediation occurs in front of a third party, and the third party is known as a mediator. The mediator has no power. They have no power to issue a ruling. They have no power to make one side do something or another, and their job is to help facilitate a resolution of the dispute, whatever that may be. Mediation is a very successful process when both sides want to go mediate, because generally they want to resolve the dispute, and a good mediator, will help them do that. A lot of people sometimes call a mediator a compromiser, and there may be some truth to that, but that's not their role. Their role is actually helping to reach a resolution. Whether that's a compromise or not is up to the mediator and the parties. Similar in many ways to mediation, and different in other ways to mediation, is arbitration. And arbitration is more formal than mediation. It is also involved with a third party, and the third party here is known as an arbitrator. The arbitrator, unlike a mediator, generally has power. They have power to issue a ruling, they have power to issue decisions or render decisions, and they have power to resolve the dispute. They do not seek to compromise. They do not seek to have the parties reach an amicable resolution. Rather, you can view them almost like a private judge, where they are actually rendering decisions based upon evidence and arguments that are presented in front of them. The PowerPoint slide says that the decision may or may not be legally binding depending upon the circumstances. I will just tell you that it is generally very much legally binding, and it is a rare circumstance where the decision would not be legally binding. In fact, many of you are too young to remember this, but years ago there was a political campaign in the state of Alabama where you couldn't go 10 miles on the interstate without seeing a billboard that said arbitration, a license to steal. Bumper stickers were created. It was a very hot button campaign topic in a particular year, a number of years ago. And what they were saying is this: the arbitrators, because they have no real oversight, you can't appeal, generally, you cannot appeal an arbitrator's decision. Once the arbitrator renders the decision, it's final. What if they issue an incorrect ruling based upon the law? Doesn't matter. It's a final decision. Well, can't we appeal it to the Circuit Court of Appeal in federal court? No, you may not. Can we appeal it to the Alabama Supreme Court in the state system? No, you may not. Is there an appellate court system of arbitrators? No, there isn't. So you can kind of see how an arbitrator has great power, and in fact In arbitration, they probably have more power than even a judge, because the judge's decision can be appealed, and a judge knows that they have the oversight of the appellate court system. There is no oversight for arbitrators like that. There's a nice little form or exhibit showing somewhat of the differences between negotiation, mediation, and arbitration. Negotiation can occur with the parties, it can occur with the attorneys, it can occur at really any time. Mediation and arbitration both are similar in the sense that they use a third party to help resolve the dispute. The third party in mediation is known as a mediator, however, and he does not decide anything. He or she may come up with a proposed resolution, but no one is required to accept it. On the other hand, in arbitration, the arbitrator is going to issue a ruling or a decision, and both sides must abide by it. Okay, that's about all that I have for the remainder of the court system and alternative dispute resolution. Thank you.